or something like that. Well, that's for people who are underwater, yeah, if you owe more than what it's worth.
It's just like a flyer that you get in.
Yeah, well, partly because there are lenders who specialize in that, and there's more money available than people are taking advantage of, and it's gonna expire soon, so Quicken Loans has been doing a lot of advertising for that, for example, to kind of entice people to do that, but it's not necessarily gonna work for what I'm doing. In general, the thinking right now is that the longer you wait, the higher interest rates are gonna go, but that's been the thinking for a while, and we'll see. Federal Reserve Board is set to meet in September and possibly raise certain kinds of rates. That may or may not have an impact on the mortgage market, because the rates in the mortgage market may already have determined that, in their own opinion, what they think the Fed's going to do. It's kind of a guessing game. Yeah, you're welcome. All right, so getting back to where we're at here in terms of listing stuff, there's a whole big long list, slides worth of a lot of information on things that are needed to take a listing. Some things, like these things here at the very beginning, are absolutely needed. You can't have a listing agreement unless you know who the sellers are, right? You know, whatever they are. And you really need a description of the property. The most common way to describe a property in listing agreement is just the street address, mailing address, and zip code. A PIN, a permanent index number, is commonly used also. This is something set by the county. This is basically the tax number for the property. We'll talk a little bit later in the course how that PIN is created, where that information comes from. And then another option, but it's overkill for this, is a legal description. Everything in Chapter 9 that we're going to cover are legal descriptions. You really don't need a legal description until you're going to transfer title from one party to another, but it is a method of describing the property. In some manner, you need to know who owns it, that they're the ones who are agreeing to list the property. You need the signature of everyone with an interest in that property who has to eventually convey it. If you don't have everybody who's got rights to the property signing them away in the listing agreement, they may not agree to do so at the closing. And then some idea of what the property is. And it makes sense to know what the property is all about. Is this the house, single family, duplex, etc.? But if you don't know if it's 2,000 square feet or 2,100 square feet, you can still list it. It's going to be harder to market it, right? So the more you know about the property, the better off you are. There's a long list, pages of data that go into the multiple listing service. Certain data, if you're working with investment property, you need to know. You really can't list an apartment building, for example, if you can't tell investors working with, buyer's agents working with investors what the rents are or what the operating expenses of the building are. There's just something that by logic you need to know, although legally there's not that, the list isn't that long. Another thing that's really important today is understanding financing. This has especially been important over the last 10 years as we've had so many upside down or underwater scenarios where the seller owes more than what the property is worth. So it may feel a little uncomfortable to you, but remember, you're making a transition from consumer to professional. You need to get comfortable with the idea of talking with clients about things like, how much do you owe on the property? Or if you're working with buyers, what is your income and what's the source of that income? As a consumer, you might not even ask your siblings what kind of money they're making, or know what your parents make. But here, you're going to have to be willing to ask people. It's part of your job. So understanding, right now, whether or not there's debt against the property, how much debt, and how it equates to the situation. On the opposite end of the spectrum, what if the seller doesn't owe anything? Maybe they'd be willing to finance it. Might give you a chance to get a higher price for the property and then greater income because they'll get the interest income as well. Anything going on with the property that matters, like special assessments, we'll talk more about what those are, or what it's zoned for. Is there a possibility it can't be used for what it's being used for right now? That kind of thing. Property taxes. What's good about the neighborhood? We talked about the question the other night about how's the neighborhood. That's all stuff that matters if you're marketing a property for sale. Can I market a property if I don't know if there's a clubhouse? Of course, right? But you're not going to do it really well. So again, some things that you need legally and some things you just need for practical purposes. We talked about these first couple of bullet points here. What stays, what goes. That's that personality, realty kind of question we talked about in Chapter 2. Sometimes sellers know things. You have to ask them more about the property, interview them about their house. If they've lived there a long time, get cool features, get information, you know, that you're gonna market. If you've never been to Aurora, for example, I think we talked about the house on Leonard Circle. If you've never, ever been to Aurora or know Leonard Circle and seen the Charlie Brown or the other, you know, the more religious Christmas displays on Leonard's Avenue leading up to that, you know, you wouldn't even know to ask. But whether you're representing a seller or representing a buyer, there's a certain tradition that's expected of people there. So if you have a buyer who's really busy and they don't have time and maybe they hate Christmas, putting them on Leonard's Avenue or Leonard's Circle may not be the best place to put them. So I mean, it's helpful if you know that kind of stuff. On the other hand, can you do it legally without knowing it? Yeah, I don't think you get sued or lose your license because you fail to tell somebody that their neighbors are going to expect them to put a Christmas display in their front yard. Unless it's in the bylaw, which I don't know that that's the case there. So anyway, just there's, you know, the more you can know about a property, whichever side of the transaction you're on, the better. But if you're going to be listing a property for sale, you might want to put in there, you know, that the Christmas display in the garage is what you're going to be expected to be putting out in the front yard. That might actually net you a more excited buyer, somebody who's really into that sort of thing. All right, these are the things that have to be disclosed. We talked about disclosure in chapter 4. So material facts, any interest in the property as a real estate agent must be disclosed. So if you're going to market a property for sale, it must say broker owned or agent owned. Same thing is true for lease. So when you sell your own property, you have to disclose to the other parties because they're going to come dealing with you directly. They have the right to know that you're a superior being under the law. So any interest by licensee must be disclosed. If there's any special compensation, again, the consumers have the right of knowing that what's happening with the compensation. Remember, all compensation regarding a transaction has to be disclosed to both parties. So ultimately, the buyer has the right to know what the listing broker is getting paid. And the seller, of course, has the right to know how much of that commission they're paying, comes out of their side of the transaction, is paying the buyer's agent. Now, if that seems odd to you, you think, well, wait, the seller's paying the commission. Let's think about this for a minute. Who really pays the commission? I've been saying the seller pays it, comes out of their money at the closing, but really, is that accurate? Who actually pays the commission on sales transactions? Well, okay, so you've been bold enough to say buyer. Now, why is that the case? Well, they write the check for the house, right? And what would most buyers probably pay if there were no real estate commissions? Less money, don't you think? I mean, sort of, it's assumed, I think, built into the market is the assumption that the seller's got to pay the 4, 5, 6, 7% commission, whatever it is, wherever it is. So buyers are accustomed to paying that as part of the asking price. The evidence is in sellers who sell without an agent are willing to sell for less money. They might net the same, but they're not paying that commission in there. So you could make the argument that either or both parties are paying a share of the fee. They're both entitled to the same information about who's getting paid what. Now, I argue that they're not entitled to know what your share as a sponsored licensee is. Your agreement between you and your sponsored broker is a private matter. But how much is going to their agent or to the agent, you know, the sponsoring broker itself, absolutely must be disclosed. And any other compensation like a home warranty or a referral fee or any other thing like that it's all to be disclosed. And of course, we talked about property condition. So automatic extension clauses and automatic renewals are not allowed in listing agreements, or excuse me, in agency agreements of any kind, with the exception of property management. And I'll talk about that when we get to that chapter, because this is a new revision to the Act. It's fairly recent. I saw the first test question go into the state test bank on this about a month ago. So in general, you're okay to just memorize, yeah, no agency agreements that automatically renew or automatically extend. They end when they end, and they have to be renewed or extended by signature or by permission. Again, we'll go over the details of how that would work with property management. But leasing or sales fits into that category.
Question.
Yes.
Under the disclosures,
Yes.
handle noisy neighbors?
That's a good question. So under the law, extraneous noise is considered a nuisance. And I don't know whether that's something that you have to disclose because it's not on your property. And so I would say it's not a disclosable item. So if you're working with a seller who's maybe leaving because they have noisy neighbors or drunken neighbors or whatever, I don't think that's an item that you have to disclose. It's a great question, right? But I mean, I don't think that's an issue for discipline. If it doesn't show up in the act as an issue for discipline, then it's something you ignore. Now, if you're the buyer's agent, maybe that's a good reason why you recommend to buyers before you write an offer on the house, maybe you should drive by at night, or maybe you should, come by on Friday evening or Saturday evening and see what the neighbors are like in those nights when you're more likely to have problems. But that's just a bit of advice, not something that you have to do or are going to get in trouble if they buy and don't like it. I mean, there are going to be scenarios where you put somebody into a house and for reasons that you didn't know, they're going to be unhappy with that, and you're going to be guilty by association. I don't know how you avoid that on some level. All right. I think this is the list of stuff that you really need to have. So the listing agreement gets identified, right? Exclusive right to sell, exclusive agency, open listing. What's the broker's authority and responsibilities in relationship to this? In other words, what do you have the right to bind anybody to do? Remember that you're probably acting as a special agent, a specific agent, just that deal, and you probably don't have much authority except to market the property for sale and make it available to other agents to show the property. Responsibilities, whatever marketing promises and plan that you put together would be mostly your responsibilities to do those things and do it in a timely manner. Who are all the parties to the contract on the sponsoring broker side, on the seller side, the firm, the asking price, what stays with the property, what equipment may be leased, like a water softener, does it stay or is it rented? And then any other way in which the property needs to be specifically identified. These are things that you really need to have clarified and clear and in place before you can list an agreement. Some of the things we just looked at are good things to have, but not absolutely required. Yeah, if you have a seller, for example, who's got a different idea than leaving and giving up possession, usually happens after the closing. So if your seller plans to need to be in the house longer, or if it's already vacant, you should know that it doesn't hurt. At some point in time, the seller's going to have to prove they own the property. Sooner is better than later. You could talk about a home warranty. What would be the benefit, other than you're going to make $20 in commission, what would be the benefit of selling the seller, convincing the seller that they should have a home warranty? Now you have a home warranty plan offered, could be like Farmers Insurance or American Home Shield. There are companies that just specify it. It's a form of insurance program. What's the point?
Residual income.
Well, there's a little bit of income for you, but that's really, it's hardly worth the effort.
Protection.
It's protection from what? You're right, but what does it protect the seller from?
Protect the house.
Yeah, the buyer has a problem, now instead of suing the seller, they call the home warranty company, hopefully. That's your sales pitch. That's how sales pitches work in this business. You say to your seller, now Mr. and Mrs. Seller, just so you're aware, this $400 warranty program that I'm suggesting you consider buying is going to generate for my office an $80 commission, $40 of which will go to me. So I want to be real clear up front that I will get compensated if you choose to go this way. But a home warranty program, Mr. and Mrs. Seller, is a way for you to have some liability avoidance. If we offer a warranty, you can better compete with newer homes that are or homes that have been more newly renovated, where things look shiny, new, maybe aren't going to break down. And if the dishwasher does go out, instead of hating you and me, they just call the insurance company, pay the $50 deductible, and get a brand new dishwasher. Plus, Mr. and Mrs. Seller, if you agree to do this, you don't have to pay for it until closing, but the home warranty company, bless you, will start covering your home right now. So it's both a disclosure, you're going to get compensated, open up with that, you have to disclose compensation, but also sell them on the benefit. That's what you should learn to do with all this stuff you're going to do in terms of your obligation to disclose agency. Learn to make agency part of your sales pitch. Here are all the things we can do for you, Mr. and Mrs. Seller. They just happen to be all the things I'm obligated to do, but here's all the things we're gonna do for you.
What's the normal if you buy a house? I mean, I thought once you signed, closed on the deal, that the house was yours, and the dishwasher went out 2 days later, and then, hey, you got fixed it.
That's correct, unless you believe that the seller knew that the dishwasher was defective and didn't disclose it in the disclosure form.
So that's one thing it covers?
No, it covers, besides appliances, it'll cover structural defects and issues, latent defects that nobody knew about. What home warranties tend to cover are appliances that, anything else with moving parts that tend to go out.
How long does it last for?
They're good for a year, and you can renew them indefinitely. You can buy a home warranty on your home right now. There's really nothing magic about them, because, like say, you could go home and buy one now with no intention of ever selling. It's like an extended warranty policy on your automobile. For a while, you could only get them when your car was a certain age. I'm pretty sure you could have a 100-year-old car with 5 million miles, and somebody, for enough money, would sell you an auto warranty policy.
Don't buyers have to have homeowner insurance when they go to purchase a house?
Homeowner's insurance is different than home warranty, which is in effect, it's an insurance program for the seller, in this case, to insure against liability that could come up. So it's different. An insurance policy is going to have whatever, a $500, $1,000, $5,000 deductible, whatever they'll have. The deductible in these policies is usually $50 or $100.
And usually you get those when they're selling their house?
Yeah, it's usually the time to do it. It's when you're representing a buyer, you can also add that into and ask the seller to cover a policy. So let's say you go into a house, your buyers are, really tight on cash, so they barely qualify for the house, though they do qualify. They can get it done, but the appliances are all 30 years old. And you're thinking, if they lose that fridge in this first year, that's going to be really tough for them. Maybe you suggest to them that they ask the sellers to spend $400 and provide them with a home warranty as part of the contract offer. So it isn't, there's opportunities for both the listing agent and the buyer's agent to suggest a warranty as a possibility. Again, study that and learn more about it. See who your office uses and what you think the programs are. I once had a seller who was a farmer's agent, and when the buyer wanted the home warranty, he agreed. The buyer never specified which one, and he provided the policy from Farmers. Oh my God, did that create problems at the closing? Everybody's like, well, we need something from the agent. The guy said, well, I'm the agent. Nobody, the whole closing just shut down for 10 minutes. Everybody scratched their heads and go, how do we do this? And finally, they just took his word on it. And I said, look, it's not that big a deal. It's what the guy does every day. But so, there's all kinds of companies that sell these. In some cases, that's all they do are just home warranty programs. Just know that it's still a form of insurance. It's not homeowner's insurance, but it covers certain specific things. Again,
I got another question
Yeah.
before you get off disclosures.
Yeah.
Real life, test question for you.
Yeah. B. I choose B.
I live in a ranch house that has a finished basement
Okay.
that I built myself.
Okay.
I've lived in it for 38 years. After we poured the foundation, I counted 13 cracks in the foundation.
Okay.
All but one of them are covered up with finished walls, and they don't leak.
I'm not sure that I would. This is just.
Do I have to disclose that?
I would say you have to read carefully what the disclosure form says. I personally am not sure that cracks in concrete are anything other than normal, right? Concrete shrinks when it dries, that's what it does. And the issue is it structurally sound or does it leak? If neither of those are issues, I don't think you have a material relevant defect. You just have concrete being concrete. Especially in residential walls, they're not reinforced or heavily reinforced like you would be in a much heavier structure. So I don't really know that, but you'd have to look at that form. I think if there's ever a question, and we'll actually use a case not like that, but similar to that in Real Estate 105, one of the cases that I wrote, where you'll have to decide in that course answer the same question. I think I would tend to say, if you disclose it, let them know that they've been here forever, they've never leaked. Then if there's a problem, you disclosed it. Otherwise, if somebody goes in and guts that basement because they decide they want to change the paneling, or they don't like drywall with paper on it, in a basement situation, they're going to use new drywall without paper on it. They see the cracks. If if you happen to sell it to an attorney, for example, who's a litigation lawyer, they might go straight to court before you ever have a chance to, even talk to them. So I think the better course of action there is to disclose, knowing that it probably doesn't kill your deal. That would be my suggestion. But that kind of question is exactly what can come to you, sitting in a listing, and somebody asks you that, and you've got to be able to give them an answer. Or help them in some way through that. All right, obviously what the commission is, you can't have a listing agreement without knowing how much you're gonna get paid and what triggers that commission. There should be some kind of antitrust wording in your listing agreement. There'll be fair housing listing, other kinds of things. Let's see, what else is here? Oh, what else, other thing that's worth talking about here, down here, the date that the contract is signed is different maybe than the date that the marketing effort begins. So this is a tip that I want to pass along to you that I had to figure out on the fly that ended up being important to me in the field. So you're at a listing appointment and you're getting to know these people and they're getting to know you. And again, this thing can take hours. And you want them to like you and to trust you. You're building a relationship and they're going to list with you and hand you their most prized possession, their biggest investment in many cases, as long as they believe you can do them the best job. Any sale where things are building toward the right relationship needs to be closed when the feelings are right and the consumer is prepared. So if all of that is building nicely and it's ready to go and you ask them the question, at some point in time you need to get comfortable with this idea of asking them, so can we go ahead and sign all the listing papers tonight? And they say, well, that would be awesome, but actually we've got about 3 weeks worth of stuff we're going to have to do before we're ready to list the house. You don't want to walk out of there without getting them to sign that listing agreement when their only objection is the timing. Now, as I mentioned earlier, by MLS rule locally, within 72 hours of the time you take a listing or something sells or changes, you've got to get that information into the MLS. That might make that sound problematic. But keep in mind, you can sign a listing agreement but not have the marketing effort start for 3 weeks or whatever time you need. So at that point in time, if you get that kind of objection, I would say to you, suggest to them, well, here, why don't we just do this, Mr. and Mrs. Seller? We'll go ahead and sign all the paperwork, but we'll make the marketing date for 3 weeks out. And I'll call you in 2 weeks and see how you're doing. And in 2 weeks, if you think you're ready to go a little early, we'll list a few days early. If you think you're going to need a little more time, we'll extend that. I'll pop by and we'll sign a single one-paragraph addendum and we'll extend that out a little bit. In the meantime, you know what you're doing, we've got a price agreed, we've got a strategy, and you're ready to go. This is part of what you end up having to do when you're selling. People make objections, not because they don't like you or because they're trying to figure out, how can I get this salesperson from stop trying to sell me a stereo I don't need? But rather somebody who knows they need your services, who's decided they like and trust you, but raises an issue that seems on the surface like, oh, that could be a problem. Don't let it be a problem. Get that thing signed up. Get them on your team. If they say, well, I'm not sure, you can say, look, we can sign this up, and before we start the marketing, you can always cancel it. Not going to put a sign in the yard. We're not putting a lockbox on the door. I just want to know that this is coming. I just want to talk to a few people in the office and let them know that, hey, this house is going to be on the market. That way maybe we get a little advance notice. And in the meantime, you just go about doing your remodeling, your staging, your cleaning, your painting, whatever you need to do. So every contract has one date, whatever that date is. But you can have dates inside that contract that do things like say when marketing starts or when marketing stops. That's different than the date the contract takes effect or the date that it's signed.
In your experience, have you had sellers often require an attorney to approve it? The listing agreement?
Once, just once. Oddly enough, and I think I have a story about them too. That was a relist. That was somebody who listed. I was a different designated agent, but within the same firm. And all I did was copy the old agreement, put the same changes in there, and they still wanted an attorney to review it. They wouldn't even look at it. Professional guy, and that was his he was a blue collar guy who worked his way up in a professional situation, and he'd been trained, put all contracts in front of an attorney. And he would not look at this listing agreement at all. He would not even compare the one he'd signed before with that one. So that's been fine. So it took 3, 4, 5 days, whatever it took, and then we did it from there. So contracts, sales contracts all the time, we recommend it, but listing agreements, very rare. Then a broker protection clause, this is for you. This is one of the few things in a listing agreement that's really for the broker. This broker protection clause says, in effect, that Mr. and Mrs. Seller, if you cancel my agreement, or if the agreement expires and you sell the house within a period of time, and that time will be specified in this clause, within a certain period of time, to somebody who I showed the property to or otherwise brought through the property, including through one of these other agents, then we're still entitled to our commission. The idea is so that sellers don't conspire, buyers and sellers don't conspire to deprive you of the commission when you cause the sale. And that happens. As I mentioned in this newsletter that I posted in the core shell designated realtor legal news from the Illinois Association of Realtors for September, it has a case in there where that was just reaffirmed. So it still happens where sellers go, oh, this is a lot of money, this 5 or 6 or 7% we're paying to this broker. Now that I've gotten to know you and you want to buy the house, why don't we just wait till the agreement expires and then we'll do it. The only way to protect yourself in that situation is make it clear that you're still entitled to the money if somebody within that protection period buys the place who had seen it while you had it listed. I used to put a year in for a broker protection clause. I've seen agents put in as little as 30 days. If the property is listed with another broker, then your broker protection clause is worthless, because now that new broker is going to be entitled to be the procuring cause if the buyer purchases it. But you know, on the listing side, you're really looking to guard against, if they don't relist it at all, in an attempt to avoid the commission. All right, so listing agreements get terminated. These, again, these are agency agreements we talked about a little bit in chapter 4. You know, the typical reason is once you're done. Once you close the house, you know, the listing agreement has no purpose, so it's done. Or if it just expires, you had 6 months to sell it, you didn't sell it, and they're not going to relist, or they're not going to relist with you, the deal is over. If the property can't be conveyed because the zoning law has changed, it can't be a house anymore, or it can't be an office building anymore, or it burns down, or it's wiped out by a flood, you know, then the listing agreement is going to be canceled. If for some reason they don't have title anymore, if you're listing a property that's in foreclosure, the sheriff's sale happens, automatically the listing agreement is terminated because they're no longer the owner of the property.
Are you required to keep those contracts then for a certain amount of time?
Yes. I get confused about the amount of time. I think it's 5 years, but it could be longer. Your broker will tell you, I think all contract paperwork has to be kept at the main office for 2 years, and in total for 5, I believe. I think for income tax purposes, you may have to keep records of your expenses for 7. So, but again, there's so many different time frames. Look that up and don't, trust me. In terms of the 2 years and 5 years, that I'm sure I'm right regarding license law. I think I have, for whatever reason, somebody along the line advised me I needed to keep everything for 7 years. So that's how long I keep all my documents. All right, so this minimum services is also important. This is an Illinois specific thing. Every exclusive agreement, whether it's an exclusive right to sell, an exclusive agency, or one of the 2 exclusive buyer agency deals, must meet minimum services. If the broker does not offer to do these things in the contract or is not obligated to do these things in the agency agreement, then it is not an exclusive agreement regardless of what it says on the top of the page. That's how Illinois law works. The reason this is this way is there are brokerage firms that offer what are called a fee-for-services model. For example, pay me $1,000, I'll stick your house in the MLS for 90 days, and then you pay the buyer agency co-op fee if it sells. In the meantime, I'm not doing anything but putting it in the MLS and throwing a sign in the front yard, that's it. Maybe not even a sign in the front yard, I'll just stick it in the MLS. Well, the state of Illinois says that's fine, you can do that, that's legal, but you're not going to do it and call it an exclusive agreement because we want our brokers at a minimum who have exclusive agreements to do these things. The Department of Justice looked at this on the federal level and said, well, if you're only doing this to try and limit a certain business model, that might be an antitrust violation by the state of Illinois. And this has stuck. This is, you know, this has now been in play for 11 years. So apparently it's an acceptable course of action. Brokers who are in that fees for services category who don't want to do any of this stuff don't like this, but this is minimum services. So in theory, if you combine MLS rules, which say no open listings, with state law, which says you have to be doing this to have an exclusive agreement, no listing that doesn't, where the broker doesn't do this stuff should ever be in the MLS, but they are. In fact, there are times for builders, for example, you'll give them an offer and then they'll deal directly with your client. But nonetheless, these are the minimum services that are required. Know them for test purposes. And they have to be included in the services you offer in practice. All right, so the last other thing to make sure that I've made this clear, and maybe at the end of the notes, before we get into buyer agency, is remember that in order to be an exclusive agreement in Illinois also, the agreements must be in writing. It is categorically impossible in Illinois to have an exclusive agency agreement on representing the seller or the buyer or a tenant or a landlord if it's not in writing. There are no oral or implied exclusive agency relationships in Illinois. They have to be an open relationship if they're implied or oral by law. All right, so let's move on to buyer agency agreements. Right?
Quick question.
Yes.
Does it happen often that you're the listing agent and a buyer comes to you without an agent?
Yeah. Somebody drives down the street,
Yeah.
sees your name in the front yard, says, let's call Sarah. They call, and you've got an incoming lead. And what do you want to do with any lead? Turn it into possible income. So unless you're prohibited by your employment agreement or because that's your house or some other reason why you can't or don't want to do dual agency, you would want to show them that property. So yes, it is fairly common. I would say that in commercial real estate, and I'm just going to give this in comparison, don't trust either number that I'm giving you, but understand the comparison. Half the sales transactions are dual agency. In residential real estate, there's no way it's even 10%. Half the transactions in residential would be dual agency if we considered in-house transactions dual agency, because some of those firms do a lot of stuff in-house. But it's much more common to see a dual agency transaction in commercial because we don't have an MLS. Your main job as the listing broker is going to be to put that house in the MLS, and then you've got all these other thousands of agents who are going to have access to it immediately. So you'll get those situations, but the odds are that incoming buyers lead much more likely if you convert them to a client that you'll sell them a different house as opposed to your listing. Nonetheless, it's important that you get them to see it because it's what they want to do. It's helpful to your client, your seller, right? It's helpful to them now. And if you can convert them to a buyer client, that's an awesome way to generate leads, right? Your name, your cell phone number, your sign, in writer in the front yard. All right, so basically any agency agreement is an agreement for the services, personal services contract with the broker, the sponsoring broker, right? So now we're just talking about buyer agency. Now you represent the buyer, or your sponsoring broker does not representing mom now, but rather representing whoever the buyer is on a given transaction. Right? The buyer is the principal, the client, and the whole idea is to find them what they're looking for. That's what buyer agency is all about. So what do we have here? We have 3 buyer agency agreements. We have an exclusive buyer agency agreement, top of the hierarchy, just like exclusive right to sell. So under an exclusive buyer agency agreement, right? In theory, no matter who finds a property for the buyer, including if they find it themselves, if they are signed with you under an exclusive buyer agency agreement, what are you guaranteed? You're going to get paid. You're entitled to a commission. Go ahead.
So like, would you give an example, grab a name, sorry.
That's right.
Would you give an example the other week that one of her friends' dad sent some listings over, but if her agent had an exclusive buyer agency thing with her.
Right. Actually, I'm glad you brought that up because this is the perfect time to address that. So one of the things that an exclusive buyer agency agreement does for the consumer is free them from any concern of who am I working with. It's easier for the consumer to say to another agent who knocks on their door and says, hey, if you're willing to buy a place, I'm willing to help you, to say, I've already got an agreement with another agent, which is exactly what you would do if you were at a party. So, and you had just listed your house for sale, but your friends didn't know yet. Your friend said, oh, I just got my real estate license. Oh, it's too bad. I'm already listed with another agent. right? And so it kind of frees you up as a consumer to say, I already have that arrangement. What it also does for the agents is clarify who's gonna get paid if something sells, almost regardless of who does the work, right? So I
Do
mean,
you need a real estate agent or a real estate, anybody to buy a house then?
no, but you don't need anyone to sell a house either. But if you want access to the MLS, somebody's gotta become your agent. If all you're gonna do as a consumer is drive up and down the street and call every listing office on every property, then you've either got no agency representation or you've got a whole lot of agency representation, depending upon how much you interact with those firms. And as an agent, one of the things you need to concern yourself with, and this is part of the discussion for this part of the text, is how much time, effort, and energy do I want to spend with somebody if I'm not sure if I'm representing them or if I'm not sure they want me to represent them. So on the buyer agency side, right, this is exactly the same as exclusive right to sell. It's just an exclusive buyer agency agreement. No matter if the buyer is signed up for this, no matter who finds the property, whatever type it is, the agent, their exclusive agent, that sponsoring broker is entitled to a commission. If we want to give the buyer some flexibility, we drop down one notch. Now, and this was the question that had been asked earlier, I think tonight, what's the difference between exclusive buyer agency and exclusive agency buyer agency? Sorry about the terminology, it's just the way it works out. What are we giving the buyer the right to do here? Find the place themselves. Now if the buyer finds a place themselves, there's no commission to their exclusive agent because the agent didn't do the work. Now let's couple this with what we learned earlier about agency agreements on the listing side. Home builders, we said, wanted to have, or going to want to have an exclusive agency listing so that if they sell it with their own staff, they're not paying a commission to their listing agent because their listing agent wasn't the procuring cause. They don't want to owe money just because they owe money. They're smart enough to know we're only going to pay you if you triggered the sale. Now, Jeff brought this up a week or two ago. How do home builders know who triggers the sale? Anybody besides Mr. Williams been to a new home subdivision? Okay, so what do you do when you go there? When you walk in, do you just walk around, or as a buyer, do you have to do something there?
No, you have to fill out.
You fill out a form, the builder registers you, and they want to know right then and there, do you have a broker? Did the broker bring you? Did the broker send you? Did we know in advance that a broker was sending you? Because that has to do with who's the procuring cause. So know this, that if you're working with buyers, and on a Sunday afternoon, while you're at home watching the football game or across town holding an open house, your buyers just look at each other and say, hey honey, let's go over and see the new homes and the new townhomes over there. Maybe we'll get some ideas. Once they walk in the door over there without you, you will never get a commission from that builder because that builder will never see you as the procuring cause. Why? Because on the day that those people walk in, they will get registered as just being there themselves. And if you don't have an exclusive buyer agency agreement with them that forces them to pay you a commission when they buy a house from that builder, know that the builder ain't paying you a fee, right? Because the builder's under an exclusive agency agreement and no agent brought those people in. This is serious business for builders. This is how they differentiate. Very simple. The broker sends a fax ahead of time, an email ahead of time, calls us on the phone ahead of time, gives us these people names, walks in with people, has the people come in with business cards. Whatever the builder's willing to accept, and some builders won't accept any of that except if you bring the people in. It's up to the builder's policy. Know your subdivisions in the area where you're working. It varies from builder to builder. But some of those things, you know, the email, the fax, the phone call, the business cards, you don't even have to be there, is acceptable for some builders. They just want some evidence when the people walk in to know that you came in off of our advertising or a broker sent you. Okay? You need to know the difference. Go ahead.
They do come in with like a card, like.
Some builders will accept that. So if you have clients, buyer clients you're working with, and they say to you, hey, we're thinking about going to the new subdivision, you don't have time, or you ask them, well, can you wait until next week, and I'll take you, no, we're just gonna go this weekend. Well, here then, please, at a minimum, take my card, they're gonna ask you to register, please give them my card and tell them that I sent you there. And if that builder will accept it, and your card gets stapled to the registration card, you'll be seen as per the procuring cause of a sale if they buy there within a certain period of time.
But they don't have to give you.
It's up to the builder. And some,
When they just say no, I'm not doing anything, they make more money.
oh, they don't think that way. The salespeople there know that you don't want to piss off the entire real estate community. I would say if you go back 30 years ago, the relationship in general between builders and realtors was much more contentious than it is today. That's just my sense. Do you agree with that? And so you got a lot more of the thinking that you're saying there. Eventually, I think the home builder community realized there's a simple solution here. If we sell roughly half our own houses, all we have to do is raise the price of our average house half a commission, and across what we sell in a year, we cover the cost of commissions. Right? So if I'm pricing a brand new subdivision for a builder, and their out the door price with a profit should be 200 grand, and they got to pay a 5% fee, which would be 10 grand, but only on half the houses, I'm telling them don't sell the house for 200, sell it for 205. Now, if you sell every other house, you're in every two houses, you're pocketing an extra 10 grand, which pays you the 1 out of 2 commissions you're getting. So as long as that's covered, most builders are perfectly fine. But again, every builder is different. And in some cases, you not only have to introduce the people, but you have to keep reintroducing people every 30 days if they don't purchase right away. I had that happen with at least one builder every 30 days. And you miss once, they won't pay you a fee. So if you've got that, hang on, Jim, if you've got that around your area, you're going to be working with those, know those subdivisions and what those rules are.
So if I'm a builder, I could legally refuse to sell to somebody that's coming to me through an agent?
No, you refuse to pay the realtor the commission. You still sell the house because you want the profit. But so I'm the agent, you're the builder, right? And your policy is very clear. You treat everybody the same way. I have to be there to register them, and if they don't buy within 30 days, I have to re-register them every 30 days, and I have to show up at the closing. If those are your rules and you treat everybody the same way, and then I fail to re-register them, they don't buy in the first 30 days, and I fail to re-register them, they come back in 45 and they close, I'm not entitled to anything.
Is that an agreement that you would have to have with the builder when you go in there?
That's the whole point. It's already set up under an exclusive right to sell, under an exclusive agency listing, and then what procuring cause is whatever the builder says it is. And that transfers through. So the listing agent would put remarks in the MLS that would say, in the agent, there's a spot for agent remarks, must be present to register buyers, must re-register every 30 days. That's the disclosure, everybody's treated the same way, and it would hold. And if you're not bothering to look at that, or you've got buyers that are kind of off functioning on their own with no agreement to hold them in place, where, if you don't tell somebody you're gonna have to pay my commission if you don't behave in this manner, the average buyer is gonna do what the average buyer's been doing for 100 years, which is just go look at houses freely, and that's up to you as to how you sort of rein people in, or how you're gonna work with this.
That's what.
Yeah, go ahead.
Between the two sort of ideas of who your client is, whether it's a seller or the buyer, I mean, which side has less risk on your end as far as somebody sort of doing something behind your back? Because the
We'll come
buyer
back
sort of
to that in
how
just a
you're
minute.
saying, but the seller,
Yeah.
the house is there. It's,
Yeah.
They know that house is gonna sell.
Right.
Versus if you met somebody and you're working with them sort of without a contract per se.
Well, with the seller, if you're going to be, once you're under an exclusive listing agreement, you know pretty well the way that's gonna go. You either sell it or you don't, you're probably gonna get paid if it closes.
Yeah.
The buyers, we're still kind of working our way there, but you're asking the exact right question. We'll answer that collectively in about 15 minutes. You have a question too? You wanna make that up? You weren't over there waving at me?
Not this time.
Okay. All right, so, again, exclusive buyer agency agreement, no matter who finds the property, the agent with that agreement is entitled to be compensated by the buyer. under an exclusive agency buyer agency agreement, if the buyer finds the place on their own, including walking into a home subdivision, you're not entitled to anything. But if they use the services of any agent at all, then you're entitled to your fee, right? So if they're going to use an agent, you're protected. If they don't use an agent, they go buy for sale by owner, which is effectively what a home builder is, you know, whatever, then you're not entitled to anything. And then, of course, the bottom of the list here, open buyer agency, just like our open listing agreement. All right, so I want you to think about this a minute, because on the listing side, earlier, I hope I made it clear, we almost exclusively work under exclusive right to sell. With, I think, a proviso that with the home builders, you should be willing to work as an under an exclusive agency agreement because it makes sense for their business model. And it should make sense for what you're doing as well. But you wouldn't work at all under an open listing. Maybe you'll go your whole career and never see one. So here we are on the buyer agency side. So under what kind of arrangement do you suppose we mostly work as agents on the buyer agency side of the transaction? I don't think you'll find this in the book. Do most buyers and their agents sign buyer agency agreements? Yes or no? I mean, I'm laying the case out for the fact that the answer should be yes. That's my professional opinion. It should be yes. But in the marketplace, how many of you here have ever been home buyers? Those of you who have been home buyers, how many of you signed a buyer agency agreement of any kind? I see no hands. So then, what's happening in the market? What kind of agency representation do we typically have with buyers? Open, because if it's not in writing, it can't be exclusive. And if you have open buyer agency with your agreements, either because you have an oral agency agreement or because you have an implied agreement, in other words, you're just showing him property, but you never came to any understanding about what the agency services were you were providing. You just jumped in your car one day and started showing houses to people. What kind of protection do you have under an open buyer agency agreement? None. So then why are we doing half of the transactions with no protection and the other half of the transactions with all the protection we can muster? Go ahead.
Oh, I was just going to ask, do agents that do this for a while, do they just kind of get lazy with it? Is that why they don't do it?
No, it's a perfectly
They
good
just-
question. So when you leave this course and you go and pass the state exam and you take your shiny little score report or pass report, whatever it is, and you go to your broker and get signed up and you start working in an office. And you remember my whole diatribe here about how important it is for brokers to get more accustomed to working with buyer agency agreements. The people who've been in the office for a while will say brilliant and intelligent things to you like, oh, nobody signs those. As a way to try and save you from yourself, as if putting forth effort in business was a bad idea. Because what's the risk of asking a buyer to sign an agreement that a lot of people don't sign? What might they say? No. And no sounds a lot like a rejection. And what do salespeople not want? Rejection. So instead, we kid ourselves, we fool ourselves into thinking we have something we don't have by jumping in our car and showing properties to anybody who wants to see them. Because we make believe that we now have business. When in reality, we have work and we don't have any idea if we have business. So why do agents not do this? Because of that diagram I showed you earlier and the talk about sub-agency. Prior to the 1990s, almost all of the brokerage activity in Illinois was practiced as sub-agency. So there was never any habit of buyers having agency agreements because they had no agency representation, because the people driving buyers around were still working for the seller. So we have 120 years of real estate agency experience working under contracts on the listing side, and maybe 20 years of trying to figure out how do we get buyers to sign agreements. Oh, let's not ask because they might say no on the buyer agency side. Now, to compare this a little bit, we get outside of residential real estate and go into commercial real estate for a minute, commercial and industrial, and get away from sales and get into leasing. So now we're talking about a landlord and a tenant instead of a seller and a buyer. Same shoes, same rules. replace exclusive right to sell with exclusive right to lease, and exclusive buyer agency with exclusive tenant representation, and you have the exact same rules, the exact same scenario. So now imagine that Verizon is looking for 20 new locations in the upper Midwest to open phone stores. And it's going to be worth $1 million a month to them to get these stores open. Do you think they're going to have any problem at all signing a tenant representation agreement that's going to guarantee a broker money when what they need to do is get those stores open and get them open quickly and in the right neighborhoods? No. Exclusive tenant rep agreements are extremely common amongst people who have serious money and a lot of business acumen. So if sophisticated business tenants, if law firms looking to rent 300,000 square feet for 20 years are willing to sign an exclusive tenant representation agreement with their brokers trying to find them the best high-rise in Chicago to locate their office, if they're willing to sign them, why are we afraid to ask buyers to sign them? There's no reason except that we're cowards. Sorry, that's just the way that it is. Now, once you get into business, it will be your decision to make, your business decision, whether you ask buyers to sign these agreements or not. But it's a risk, and the risk is your time, and your time is valuable. And if you work with buyers a lot who don't close with you for whatever reason, that's an early exit strategy. Because eventually you will go home and you'll say, sorry, honey, I was wrong. I guess I can make more money delivering milk at 5 a.m. Go ahead.
Do you personally make everybody sign that?
Haha, good question. So let's shift into what my experience has been in this regard and why I am the preacher for signed buyer agency agreements. You know, if you want to know why it's a really, really, really good idea not to smoke, who do you ask? Ex-smokers, not people who have never smoked, right? If you want to know why it's a good idea not to drink, who do you ask? You ask the people in AA, right? They're the crusaders. They're the people who can tell you every reason why not. That's me. So I'll give you several stories here. These are all true, factual, to the point, and very common. It's not unique to me. So I was working with a young guy who was a professional. He was in a managerial position. He was looking to buy his first townhouse in and around Aurora. We were showing places out by Fox Valley. This goes back to like 1998. And we got within 1% on one particular unit in a subdivision called Hunter's Glen. Familiar with that area? He didn't really like the unit. And this is a funny thing. When a buyer doesn't really like a place, they make a low offer. You know, if they want to make an offer, they'll make a low offer because in their subconscious, they're thinking, oh, yeah, I'll buy this place, but they don't really want it. So they never get serious. We got within 1%. And I thought about it later, and I think if this were to happen to me today, I hope I would be savvy enough. Had I agreed to just reduce my buyer's co-op fee from 3% to 2% on that, the seller would have gladly come down another percent and we would have closed the gap. But I didn't think about it at that time. It's kind of hard to know. So right around the 1st of January, must have been 99, I guess, I took a listing out in Diamond Bay, out in that general area. And so I told him that this was coming, and he was intrigued. He looked at it, he really liked it. And of course, I did the whole dual agency thing with him ahead of time and all that, because he was already my client, because I was showing him places. And he said, this is awesome. Now, on the last place, when he was ready to make the offer, he had his dad come through. Very common for younger adults to have the dad and uncle, whatever, come through the place. And I got to know his dad a little bit, and I liked them both. We had a good relationship. And so he said, this is great, because after this holiday weekend, he said, I'll talk to my dad over this weekend, and we'll come back next week and we'll look at it together. I'm thinking, this is awesome. Dad's involved. Cool. So I get a call Monday morning from my client who says, hey, good news. I said, really? What's the good news? He goes, I bought a place over the weekend. Now I can tell you, when you're in sales and this happens, that hurts, straight to the pit of your stomach. But now you're trying to be nice and polite, right? So I said, so tell me what happened. So here's the story. So that weekend, on New Year's Day, not New Year's Eve, so everybody was sober, hungover maybe, but sober. On New Year's Day, they're all, him and a bunch of buddies are hanging around watching college football games or whatever they're doing. And the friend who owns the place in Hunter's Glen says, hey, by the way, everybody, if anybody knows that somebody looking for a place, I'm looking to sell my place, I'm going to put it on the market in the next month or two. My guy immediately pipes up, oh, what are you asking for it? So this guy throws out a number, says, well, I'm going to ask 134. My guy says, I'll give you 126. 5 seconds of silence, they cut a deal right there on the spot. Now, how did my guy know what the place was worth? I taught him. I showed him a couple of places. We'd almost gone to contract. I taught him everything he needed to know about that place. And what did I get for my trouble? Nothing. Now, did my guy, did he do anything wrong? Anything immoral, unethical, illegal? Who's the idiot in the picture? Right here. I'm the one who had the opportunity to do something different, and I took no effort in that regard, right? So I lost the deal. Now, there's a really good chance if I'd had him under an exclusive buyer agency agreement, he would have remembered, oh yeah, this is going to cost me 3%, and said to the guy, you know what, I can pay you, maybe 100 and whatever, 129, but you're going to have to pay my agent 3%. Or, I can't, I'd offer you 126, but I got to pay an agent 3%, so I'll pay you 123, or whatever he might have remembered and done that, and the deal still would have gone together. Who knows what would have worked out? And I would have been compensated for my time.
Was it only because you showed him in Hunter's Glen?
Yeah, I mean, I think it's true if I had shown him in other places, he'd still have had a sense. Now, the seller knew how much the place was worth because he talked to a listing agent who gave him a market analysis, and that person didn't have anything or get anything either. So back to your question about, who sort of does something around behind your back, neither one of them did anything wrong, but in both cases, we lost out. And in my case, the answer would have been a buyer who I'd showed a lot of property to have under an exclusive buyer agency agreement. That's the only way to solve that problem. If I'd had him under an exclusive buyer agency agreement, would not have solved the problem for me.
But isn't it hard to change that? Because that's the way it works. The seller knows it needs to get a listing, but the buyer's got free rein. Is this just how it goes?
Yeah, so let's talk about the risk. So we're trying to change the culture. I'm sure that everybody in this room at some point in time in their lives has found something worth crusading for. And all I'm asking you to consider crusading for is something that affects your own pocketbook. It's nothing to do with me. Go back, whoever asked the question about do I get buyers after and I'm not even remotely done telling you my stories. I work with sellers. Or I work with commercial property, do property management, do leasing. I would much rather be on the other side of the transaction. Buyers are way too loose for me. So the risk is I explain agency to him, tell him, look, Mr. Buyer, here's how I work. If you want me to be dedicated to you and provide you with current listings and updated information and provide you with everything you need to know, be timely, be on the spot, be available for you whenever I can, I need to know that you're going to buy through me if you purchase. So what I'm asking you to do is sign this exclusive buyer agency agreement that says, if you purchase a property that fits the criteria that we've defined in this agreement, the right side, it's a townhouse, certain bedrooms, bathrooms, maybe a DuPage County address in Aurora, define it however you want. Within the confines of that definition, if you buy a property, you'll guarantee me that I'm going to get paid. But understand this, Mr. Buyer, if the seller pays me the fee that I'm asking for in this agreement, you'll owe me nothing. I'm just asking you to cover this if I show you a bunch of properties and you buy a for sale by owner, or you stop working with me and buy from your brother-in-law, or if you walk into an open house and say one day, hey, this is cool, I'll take it. I need to know that those possibilities are eliminated. Otherwise, I'm better off spending time finding a prospect who will be more loyal to me than you're willing to be.
Cliff, in real life,
Yeah.
how much pushback do you get from people?
It depends. My experience is that the pushback you get is pushback you probably should use to filter. Very common, for example, for people who are new investors to go to every real estate agent in the market and tell them what they're looking for. And then you got every real estate agent in the market doing searches for the same thing, and nobody bothers to ask them, are you working with anybody else? So for example, I missed a $5 million apartment sale, God, 10 or 12 years ago, when I got a guy a listing 30 minutes after somebody else. He had sworn to me I was the only agent he was working with. Absolutely lied through his teeth. Because, you know, people need to understand there's one MLS, there's one set of market data, and if you are going to engage multiple agents to do the same thing, one of us is wasting our time, or everybody but one. And as agents, you really need to say, I don't want to be a free tour guide. I don't want to be searching data for the sake of sending you stuff when all I'm doing is sending you stuff that somebody else has already sent you, or is going to send you an hour later. So you get some pushback, but the question is, will you find enough buyers who will be loyal to you? And there I believe the answer clearly is yes, because there are agents who do it. There are agents who function on that kind of basis.
Do sponsoring brokerage offices usually have policies on this one way or the other?
They
For
can.
instance,
They can, but they don't have to.
If there's a walk-in, do they care if you're telling that walk-in, I expect you to have a...
Again, that depends upon the broker. So I couldn't give you any stats, any statistics. I would be willing to bet that the brokers in general are willing to let you waste all the time that you want, so long as they're meeting their numbers. Again, it's not their time, and for you, your time is valuable.
But if you have a walk-in coming into the office, and if you say, I'll work with you only with an exclusive buyer agency agreement, and that person walks out the door, the sponsoring broker, in effect, is potentially loses.
Yeah, if they, and I don't know, again, whether they would ever even know that. Or, you know, but you could talk to your broker and see what they say and see what they think, or where, even when you're interviewing them, see what they would say and see what they would think. I don't think from the standpoint of what my broker would think, because that's me, right? And I want my agents to be more productive and more happy and more fulfilled, and I think that requires the exercise of discipline, something that the average buyer's agent does not exercise. That's my experience, it's my view, it's an unshakable opinion. You know, based upon experience, not just for me, but of watching people that I've sponsored.
What if you're looking in like Huntley or somewhere kind of far away, and
Yeah.
then your job changes you somewhere else, and then you decide you're gonna look in Big Rock or something, and they're
Yeah.
kind of different, like far away from each other.
You're-
Could you?
Think about a listing agreement. When you have a listing agreement, you know exactly what you're selling. I think that's what Daniel was saying earlier, right? You've got the address, the property, you know exactly what it is. With buyers, you don't really know. So in the agency agreement, you have to define it. So if you have an exclusive buyer agency agreement that says you're looking in, let's say in McHenry County, and then you decide, oh, that's not going to work, you can have a different buyer agency agreement with a different broker for the exact same criteria, but in Kane County,
Okay.
because it's a different
Say
assignment.
McHenry County and a 30-mile radius past it or something like that?
Anything, however the parties want to define it, yes.
Say anything in Illinois.
Yeah, absolutely. As long as both the broker and the client are willing to accept it, absolutely. So here's a real life case that went to court. Paraphrasing it a little bit, older couple comes into the area and they have grandchildren in Naperville and they have grandchildren in Deerfield. And they say to the broker that their first broker they talk to, we're buying in Naperville or we're buying in Deerfield. We're not going to live in between. Our kids choose to live there, but we're going to live in one or the other. And so they hire two brokers, one to find them property in Naperville, one to find them property in Deerfield. And they sign exclusive buyer agency agreements with both. The only difference in the assignment is one is Naperville and one is Deerfield. Now, true to form of how things can go in real estate, for whatever reason, the Naperville agent missed a house. And the Deerfield agent, I don't know if she had extra time in her hands, if she was struggling because she couldn't find them what they wanted in the area around Deerfield, or what the deal was. She pulled up a listing that they had not seen. She sent it to them and said, have you seen this? Oh, no, I don't think we've seen this. Well, let me take you and show you the property. So the woman under the exclusive agency agreement in Deerfield shows this other house in Naperville. These buyers like it, they buy it, they close. Now the question before the court is, who's entitled to the fee for the buyer agency? The broker who maybe didn't do his job, but had an exclusive agency agreement, or the woman who otherwise, absent an agency agreement, would have been the procuring cause. Now, which way do you think the court ruled? The paperwork went to the agent that had the exclusive agreement. So the woman who closed the deal got nothing. Well, the office got the money, and then they had to give it up. once they were sued by the other broker. This is the beauty of what a buyer agency agreement does. So if you're gonna work for an investor, for example, who can't decide if he wants to purchase property in Aurora or Joliet or Elgin, and you don't wanna work in Joliet or Elgin because you only know Aurora, you could say, well, look, here, I'll tell you what, I'll be your exclusive agent in Aurora or whatever, this environment is, define it however you want. And then you go find a broker in Joliet and you go find a broker in Elgin and pit us, the three of us against each other. But I know that if it's within this area, you're paying me and I'm your only guy here. Perfect case of, exclusive agency agreements. It saves everybody from confusion. And again, why would you work with buyers who can do whatever they want to do on a whim and all of the foundational work you've built up until that point in time is gone? Every bit of it. We don't do it with sellers. The only reason we don't do it with buyers is because we don't do it with buyers.
I have a question. You mentioned that in the exclusive buyer agency agreement that if the seller pays your fee, then the buyer doesn't owe you anything. Is that something you would tell the seller once you give them a price?
Well, with the seller, they're going to know right from the beginning as part of their listing that they're paying the entire fee out of their side of the proceeds. That's going to be part of your pitch. So whether a buyer comes to the seller's house under an exclusive agency agreement or not is really immaterial to the seller. The whole idea here is whether you're willing to force your buyers to commit to paying you something so that they don't go to the home builder without your business cards, so that they stop and think before they buy a for sale by owner. Just kind of a fairly quick, and again, another true scenario, I had 3 sellers that I was working with at the same time, 1999 or 2000. All 3 of them were looking at about the $350,000 range. I had worked with 2 of them on selling houses in Aurora. The other one I did a referral with out in the Dixon-Sterling area. I lost all 3 of those in a 1-month period of time. One of them bought, after I showed them a lot of properties around, one of them bought a house from a family member. One of them, we went to contract on a house, but it had a bad inspection, and I actually advised them to cancel the deal. They ended up buying from a builder where they had seen the townhouse 2 years earlier, and the builder would not give me procuring cause when I brought them in. And the other bought a for sale by owner that had actually been listed by another agent in my office. And when it went for sale by owner, I thought about contacting those people to see if they wanted to sell. I had even shown that property before, but before I could get myself motivated enough to make that prospecting phone call, my clients purchased the house. If you just say $300,000 a piece at 3% a piece, that's $9 grand a piece. Probably my gross commission before split with the broker, it was probably a $30,000 I didn't get, but I put the effort in, kind of thing. So you just have to decide. Again, I decided in a lot of different ways. But if you're going to work with buyers, I would highly recommend you have signed agreements. Other questions about this? Go ahead.
Well, not about this.
Let me just. Any other questions about buyer agency? Go ahead.
The sponsoring broker would have the agreements for you?
They should have buyer agency agreements. If not, the association should have agreements that you can look at.
Just define them and make them your own?
Because you
Because you would be putting whatever agreement you want.
Yeah, I mean, it's whatever your sponsoring broker's got to approve the agreement, right? They're going to have to sign off on it. It's also, remember, you owe a disclosure of designated agency in Illinois. This is the perfect way to disclose designated agency. Even if you don't sell it, and you start with exclusive buyer agency agreement, they won't sign that, offer them exclusive agency. Maybe they'll take that. At least you're covered on some basis. If they won't take that, at least get them to agree that you're their agent in writing, and in that disclose that you're the designated agent of the office. Just the process wouldn't be that complicated. So here's how this works, blah, blah, blah. Oh, they don't want to do it. Well, then here's something else, is another option, blah, blah, blah. I really think it's 5 minutes out of your life to try it if you aren't going to pin them down. Today, I think, in my situation, I would say to people, if you're not willing to commit to me, I'm sorry, but I'm not willing to commit to you. And for me, if my sponsoring broker wouldn't stand behind me on that, I'm going to find a different broker. I would not have felt that way, clearly, when I first started. It's great to feel busy. It's much better to actually be productive. Please understand that however many of you from this course go into the field, if you don't learn to think in this way, whether it's on this or other things, most of you will never make it. because you're thinking like consumers. You're thinking like people. You need to think like business people. And business people don't waste their time. They don't let customers waste their time. Be polite, be tactful, be frank, but don't let them waste your time. Go ahead.
You made a comment earlier about closing the gap by changing commissions. You said that, say the people were we're talking about townhouse for 126, and the guy
Yeah.
was, so you were saying how in a different type of situation, if you were to lower your commission structure on both sides of the co-op, could you potentially then come to a lower number of what
I had
the
a
sale would be?
townhouse seller who had just purchased the property the year before. All they wanted to do was get their down payment. No, all they wanted to do was get out. They were willing to lose their down payment. They just wanted to get out with no dollars. Brand new construction, so the lender had failed to properly escrow for taxes. So what my seller thought they owed on the property was off by a year and a half's worth of, by 16 months worth of property taxes. So when it came down to the numbers, we realized we're never gonna be able to get enough money to cover the 6% fee. So we got a deal where there was room enough for a 4% commission, and I said to my wife at the time, I said, we're probably gonna have to take 1%, because why would the buyer's agent ever reduce their fee? So hang on, let me finish, this is important, this is really important to me in this thing, right? So I called the buyer's agent and said, here's the deal. My clients can't afford to take your offer, though they would like to. Are you willing to drop your fee 1%? And the buyer's agent immediately said, oh yes, I'll absolutely do that. And so I said, okay, because I'll do the same thing, and that's where the 2% came from. We went from a 6% fee to 4%, and I asked her later, why would you do that? And she said, oh, because if my buyers didn't buy this, they were gonna buy a builder's home, and we didn't take them through it. So see, this stuff kind of came together. So it's a good thing that I asked her.
You'd rather make the transaction at a lower rate than
Then-
not make it at all, right? I mean,
Yep,
numbers game at that
exactly.
point.
My sellers walked away with $168. I couldn't get the numbers any tighter. I was too scared that, I didn't want, marching orders. We'll sell them anything, we're just not writing a check at closing. So that was it. So yeah, that was it. We finalized that, yeah, so at times you might be smarter to just say, you know what, let's put the
Because
deal
you've done
together.
that much work already, I mean, why come all the way to the closing?
Exactly.
And be off by a percentage?
And again, that's a mature business decision. One I didn't see yet when I had this townhouse in Hunter's Glen thing, when I figured out later when I had this Oswego deal that, oh, I can make this happen, but I might have to be willing to take $1,300 instead of $3,900. Okay, for those of you who look at the slides, there's, again, the agreements are pretty much the same. I think this stuff is pretty much all the same. Again, the whole idea of procuring cause that we talked about ties completely into these agreements. Hopefully you can follow all that stuff. And again, buyer agency is just a little bit different simply because the nature of the assignment is different, right? You don't have a specific property, you've got to go out and find it. So it's up to you guys, decide how you want to do this, how you want to function. But I just wanted to raise this issue now because there's a good chance that nobody else will raise it, and I don't want you trying to figure this out when you've been in business for 2 years. Figure it out going in. Just understand how you would function as a buyer. Would you ever, drive down the street and call somebody randomly and then let them show you the property and never talk to them again? I think most of us would do that without thinking about it twice. Well, on the agent side, that means you're now spending time showing a property, getting your hopes up for something that has almost no odds of closing. So just think about how you want to spend your time and try and convert your thinking, your excitement into this, into how a professional thinks. It's different. Again, I think the stuff you could probably just read. When we talk about a CMA later, we'll talk about this really from the standpoint of how it's prepared for a seller. But if you're going to do buyer agency, you should be prepared to do a market analysis for your buyer as well. How do you know what they should offer if you don't do a market analysis? So keep that in mind, and in the next course, the Real Estate 105, when we look in the MLS and we look at how the CMA tools in there work, you'll see that you could do either a seller's CMA or a buyer's CMA. You should, that's something you should think to do. Too many buyer's agents say, well, they're asking 200, and we want to, that means it's probably worth 195, so we'll offer 190. You need to put more thought into it than that. You really need to do your own independent analysis and determine what the property is worth. Sometimes you have a buyer who really wants a place And your job should be to tell them, they're asking 200 and the place is only worth 175. You're gonna have to offer like 160 to even have a shot at getting it right, and maybe you should look for a different property. But you've gotta do research ahead of time to know that that's the case. Oh, one other thing, we'll just do this and then this, I think this is the last thing now, right? Yeah. Contemporaneous offers. So this is also test question fodder and something you need to know for practice and something that also has only existed in the Act for about 5 years. So dual agency has always been the big bad boy in the License Act, the thing you need to watch out for. And many of my colleagues would complain that they thought contemporaneous offers was even worse. And I had never thought about this because I had never run across it. But when the market was screaming busy, this was happening frequently. When you're in a buyer's market in particular, lots of buyers, few sellers, it's not at all unusual to have the opportunity to write multiple offers on the same property representing different buyers. So what the Act is saying today under contemporaneous offers is that's also a potential conflict of interest. You've got buyer A and buyer B, and all of a sudden your two buyers are being represented by you on the same property and they don't even know you're being duplicitous because there was no disclosure obligation. So now there is. If you're going to write more than one offer for different clients, we're talking about, you know, client A, client B, you're writing an offer for each of them on the same property, they both have the right to know, not what each other's offers are, but that you're representing multiple parties. Have to disclose that in writing today in Illinois. Again, called contemporaneous offers, right? So you're not disadvantaging anybody, you're simply disclosing to them. If an offer has expired or it's no longer good and you're no longer working with those people, or a buyer says, yeah, just forget that place, we'll go look at something else, you wouldn't owe them that if 30 days later you wrote another offer for somebody else. But again, you know, it was very common and can happen again anytime. If you're in a position to do that, you must disclose that. Any other questions about anything at all up through this chapter? Good thing, because your fellow classmates would have clubbed you if you asked any questions. I will be happy to hang out and answer questions. For those of you who have not yet read Chapter 7, you will notice a complete sea change when we get to that. This is the last time in the course when 3 chapters fit together this neatly. Starting to go forward, we'll get to cases where you've got some pairings, but we're also for a while going to be kind of immersed in a real estate law class. Trust me, I will, you know, try and make this stuff less bad when you get to the classroom. But really, you must read Chapter 7 before you come to class, or you probably won't have any idea what I'm talking about.